Good afternoon, everyone. Welcome to the City of Franklin Beer Board meeting. Today is Tuesday, June the 10th. It is 4 p.m. Central Time. We will start with our call to order with a roll call vote. Alderman Barnhill.
Present.
Thank you. Alderman Caesar.
Here.
And the chair is here as well. Next, we'll move forward to setting of the agenda. This is for any discussion or removal of items from our agenda as it is currently set. If there are any items to be removed or amendments at this time would be the opportunity to do so, or I'll take a motion for approval as the agenda is currently set.
Motion to set the agenda.
Second.
Motion has been made and properly seconded. All those in favor?
Aye.
Aye. We'll next move forward to citizen comments. At this time, I do not have any citizen comments. If any need to be brought before me, go ahead and do so. Seeing none, we'll move forward next to our approval of the minutes. This is consideration of approval of the minutes for May the 13th, 2025 Beer Board. Is there a motion?
Motion to approve.
Second.
Motion has been made and properly seconded. We'll now move forward to a roll call vote. Alderman Barnhill.
Yes.
Thank you. Alderman Caesar.
Yes.
Thank you. And the chair votes yes as well. Next, we'll move to new business. This is consideration of application of Little Hats Cool Springs LLC, DBA Little Hats Italian Market, 980 Meridian Boulevard, Franklin, Tennessee, 37067. Andrew Hurst Dodd, managing agent for on-premises consumption.
Good afternoon, Beer Board. This is an application for a new restaurant. And Andrew Hurstad is one of the owners, and he's here with us tonight. The applicant does have a Nashville location, so this is not the first restaurant for this business, but it is the first one here in Franklin. The application and inspections are all complete, so staff is recommending approval, and I will let Andrew tell you a little bit about the business and answer any questions you have.
All right. Thank you and welcome.
Hey guys, how are you?
Great.
We're just looking to sell some beer at our bar. We have a small indoor-outdoor bar. We have a patio that's properly deviated, and we have a program for training, all the things that we would need to make sure that we're doing it safe and properly. We're just hoping for y'all's approval.
Excellent. Thank you very much, sir, for
Appreciate
that summary. I'll now open it up to any questions or comments from the board.
I don't have any.
I don't have any. I'm driven by the market, and I am excited to be able to come in and maybe make this motion to approve the application of Little Hats Cool Springs LLC.
Thanks, guys. We're excited to be in Franklin.
Thank you. Motion has been made
Second.
and now properly seconded. Next, we'll move forward to any further discussion. Seeing none, we'll move forward to a vote or a roll call vote. Alderman Barnhill.
Yes.
Alderman Caesar.
Yes.
And the chair votes yes as well. Thank you, Mr. Hurstad. Appreciate you being
Thank
here,
you, sir. Appreciate you.
Next, we'll move forward onto our agenda to, this is item number 4 on our agenda. This is consideration of application of Paddle Dog Adventures, LLC, DBA The Salty Taco, 401 Cheltenham Avenue, Franklin, Tennessee, 37064. Jack Abrams, managing agent for on-premises consumption.
All right, and this is another new business here in the city. There is an existing restaurant. This is at the pool at West Haven, and there's a pool cafe. However, they were not a beer permit holder, so this is a new business and a new beer permittee at this location. You may be familiar with Mr. Abrams, who's here. You can come on up. And his attorney, Jenna Burrell. Mr. Abrams also owns another establishment in Franklin, Paddle Dog, which is also at West Haven and has a beer permit. This one, we are still waiting on the certificate of occupancy, so staff would request a contingent approval upon receiving the certificate of occupancy, and I will let them talk to you a little bit about this business.
Excellent. Thank you both and welcome.
Hello, good afternoon. I'm Jenna Burrell. I'm representing Salty Taco here, and this is Mr. Jack Abrams, the owner. He will be running the poolside cafe, and we can answer any questions that you have for us. All servers we are seeking a Tennessee alcoholic beverage permit as well. So all servers will be trained and have TABC permits, which of course covers IDing, absorption of alcohol consumption and watching for any kind of red flags. So all of our staff will be trained. This does include the pool area, which the staff will be patrolling as well.
Thank you, ma'am. Thank you, Mr. Abrams, for
Sure.
being here. Anything else to add to that?
No, we're looking forward to it. We currently have a beer permit with our other location, and it's been wonderful. So the whole, I know this is separate from TABC, but it's been a journey so far, and it's learning a lot for sure. So have been enjoying it.
All right, thank you, Mr. Abrams.
Sure.
I'll open it up for comments and questions from the board at this time.
If he's got a restaurant, another restaurant, he's going through the same thing for this one, and he knows what the drill is. I'll make a motion to approve the beer permit for the Salty Dog based upon the CO, based upon his getting a CO.
I would second that. I do have one question, and it's more of the time that this restaurant's going to be open, because it's poolside, I assume, and I don't have privileges to swim at West Haven, but I'm assuming that's seasonal. And so will this restaurant or this location be open outside of the pool availability?
That's a good question. So as of right now, we are just going to be seasonal.
Okay.
So we'll probably close up I think the pool closes first week of September, so we'll close up first week of September.
Okay.
Short season.
Thanks. Just a question out of curiosity. Thank you.
Sure, absolutely.
Motion has been properly made and properly seconded. At this time, we'll move forward to further discussion and/or question. And I do have one, and it is for the applicant. Because this is, we'll call it poolside service, and as you had stated, that servers may be walking the pool area and checking, are there lifeguards on site as well?
Yes, there are lifeguards on staff at all times.
And so the lifeguard company is aware that you are adding beer or alcohol to pool patrons?
Yes, they're aware.
Okay. And I do have a follow-up question on this, and this is in a follow-up to what Alderman Barnhill said. I recognize that you already have another location, but because this is poolside and a lot of summer activity going on, what's going to be the process for you to identify those that are 21 and above?
Sure. So what's great about this location is we've hired all 18 years and older servers, front window staff, and so it will be anyone who appears in our safety protocol. Anyone who appears under the age of 30 will be ID'd for every alcoholic beverage purchase.
Okay. And then, again, since it's poolside and there'll be a lot of kids, a lot of underage people around, are there going to be any stamps or any wristbands or anything like that? How is that monitored, or is your staff also walking the area looking for underage drinkers?
Sure. So
Yeah.
our
And
staff.
not
sorry,
that I'm
sorry.
assuming that y'all are going to do such.
Of course.
But sometimes young people are young people and just asking the question.
Of course, it's yes, our staff and the pool staff will be patrolling the area. They always do monitor that kind of currently, and so with us bringing the beer as well, they will just continue to be monitoring, and our staff alongside them as well.
Okay.
Sure.
All right. And I take it since it's poolside, these will all be non-glass containers as well.
Yes, cans and plastic cups.
Okay, excellent.
Sure.
Well, those conclude my questions. Any additional follow-up comments or questions from the board? Seeing none, we'll move forward to a roll call vote at this time. Alderman Barnhill?
Yes.
Thank you. Alderman Caesar?
Yes.
Thank you, and the chair votes yes as well. Thank you, Mr. Abrams.
Thank you. Thank you so much.
Absolutely.
Thank you.
Next, we'll move forward to the next agenda item, which is agenda item number 5. This is consideration of application of B&R Restaurant, LLC, DBA Franklin Chop House, 1101 Murfreesboro Road, Franklin, Tennessee, 37064. Brittany Burton, managing agent for on-premises consumption.
So this is an existing business. You're probably familiar with Franklin Chop House. There are new owners, so that's why we're here seeking a new beer permit. And Robert Crockett and Brittany Burton are the new owners, and they're here if you want to come on up. So they're here to answer any questions you may have. The application and inspections are complete on this one, so staff is recommending approval, and I'll turn it over to the owners.
Excellent.
Hello.
Welcome.
Thank y'all for having us.
Absolutely. You can go ahead, take the floor, give us a little bit about your new ownership.
Yeah, so Brittany and I have actually both worked at this restaurant for over 15 years each. So I've been there a very long time. I've been there since 2008. She's been there since 2010. It's been the same owners ever since that's opened in 1995. We're looking to kind of just continue what they started and that legacy and keep it a family restaurant. Like she said, many of you may know what this restaurant is. To that point, we would just ask that, if possible, anybody in this room keep this as confidential as possible, just because our staff is not being told until next week, and we just would like for them to hear it from us. But other than that, we don't have any big changes to make. Been in business for 30 years, and safety protocols and trainings are staying the same and all that. So we've been blessed to have a great place to work at.
Thank you very much for those comments. I will speak to your confidentiality statement. Unfortunately, because this is a public forum, we cannot do that.
I understand.
But I can assure you that those that patron, myself included, Franklin Chop House, look forward to the continuation of your restaurant. So I'll open the floor for any comments or questions from the board at this time.
So basically the staff is the same. There's nothing more than just ownership change, and signs, bar, tables, everything remains the same. All those wonderful pictures of old Franklin.
Yes.
Yeah.
Yes, sir. Yes,
You know,
sir.
I think I see the chairman's picture in there at some point in time.
A lot of good pictures.
I don't remember which wall he was on.
We got a few pictures on there. So.
Motion to approve.
I'll second that motion.
Motion has been made and properly seconded. Is there any further discussion?
Well,
Go ahead.
There is one question. Is the beer permit in both of your names? It just says Brittany Burton on the application.
So the applicant is B&R Restaurant LLC. The owner is a corporation, and so
You only need, okay.
right. So that is the name of the owner on the applicant, and it's DBA Franklin Chop House.
Okay, all right.
Go ahead, sir.
my question was about the thousands of people that are probably watching this right now. It may be
Tens of
difficult.
thousands.
Tens of thousands. It may be difficult, so you may want to go do some damage control right away. But no, welcome to Franklin again, and we're excited to see this continue, assuming that this goes forward with a vote.
I will go ahead and strike the gavel to the tens of thousands of people watching and swear them to secrecy at this time. And we'll move forward to a roll call vote. Alderman Barnhill?
Yes.
Alderman Caesar?
Yes.
And the chair votes yes quietly for you as well.
Thank you, guys.
Thank you very much. All right, next we'll move forward to, this is agenda item number 6, and this is consideration of application of the Drury Development Corporation, DBA Drury Plaza Hotel, Franklin, and that is at 1874 West McEwen Drive, Franklin, Tennessee, 37067. Timothy Tolbert, managing agent for on and off-premises consumption.
All right, so this is another existing business with an ownership change. The owner on this one is also a corporation, and I believe, sadly, there was a passing of one of the owners, and so that has necessitated a new beer permit. Mr. Tolbert is the general manager. He's here this evening along with Rob Pinson, who's the attorney for Drury, and they're here to answer any questions. The application and inspections are complete on this one as well, so staff is recommending approval, and I'll turn it over to you, gentlemen.
Gentlemen, thank you very much for joining us this evening, and please accept our condolences.
Yeah, it's the entity staying the same, hotel staying the same, just because of some estate planning, because of the passing. More than 50% of the direct ownership has transferred to various trusts and voting trusts and other entities. So that's why we're here. But I'll let Tim answer any operational questions you may have.
Hi, Mr. Tolbert. Go ahead, sir.
Nice to meet you. I have actually been with Drury Hotels for 30 years. I'm new to the Franklin market. I've been at our airport location for the last 23 years. So we have a very basic operation where we have a reception every evening where they can have beer, wine, and cocktails. Plus we have a little market where they can purchase our canned beers and or wine. So.
Thank you, Mr. Tolbert. We appreciate you being here. I'll
Yeah.
now open it up to question or comment from the board.
So that's the off-premise consumption. the purchase of the, in the market after you've had your happy hour or
Yes.
whatever you?
Yes, sir.
Okay.
Any additional comments or questions? Sir, go ahead.
My only other comment, if you've been at the airport,
Yes, sir.
we say here, bless your heart.
Yes. And other than because I'm still living out in Mount Juliet, other than the commute, I am very happy to not have to deal with the whole airport market.
Yes. We welcome you to Franklin.
Yes, I'm excited.
I'm just remembering, because I've stayed at the Drury a number of times and
Uh-huh.
and a bit of a Drury fan. The process I'm trying to recall, if I want to go down to the evening reception, there's a bartender there that's
Yes.
licensed, that's dispensing, and so as far as certification and management of dispensing, that's all controlled by them.
Yes, yeah. You have to be a guest. You cannot come in and purchase any. So every guest is given a coupon that we track everybody. So at most, anybody can have is three drinks. So there's not a chance of over serving because, and everybody that serves has been through the Serve Safe alcohol training, and that includes anybody that purchases stuff through the market. Everybody on the staff that has anything to do with beer or alcohol has been through the Serve Safe alcohol training.
Okay. No further questions for me.
Motion to approve?
Second.
Motion has been made and properly seconded. We'll move forward to any further discussion. Seeing none, we'll move forward to a roll call vote. Alderman Barnhill.
Yes.
Thank you. Alderman Caesar.
Yes.
And the chair votes yes as well. Thank you very much, gentlemen.
You're welcome.
Next, we'll move forward to the final item on our agenda, which is agenda item number 7. This is discussion of issuance of beer permits contingent upon temporary certificates of occupancy.
Good afternoon.
Good afternoon, sir.
I don't normally come up to this side of the podium, so glad to be here. Our office has been asked to discuss a question regarding the issuance of beer permits and their relationships to certificates of occupancy. So if you'll bear with me, I'm going to read through just some general law and some thoughts from us as far as that goes, and then I'll open it up for questions. Specifically, I've been looking into whether we should amend the municipal code to allow beer permits to be issued based on a temporary certificate of occupancy, or CO for short. After reviewing the plain language of the city's municipal code and the relevant legal authority, our general recommendation is that the city should keep the code as it is. But let's get more specific. Let's look at the beer permit requirement. The municipal code sets forth in section 8.2.10.12. It states that no beer permit for on-premises consumption can be issued until the city recorder has obtained approval of the premises from the building inspector. In practice, approval from the building inspector we have generally interpreted to mean the final certificate of occupancy, not a temporary one. Well, what is a final certificate of occupancy? Let's dive into that. Section 12.1053 of the city's code defines a final CO as being upon the completion of all construction work and site improvements in accordance with the approved plans and all applicable requirements. So, in layman's terms, I called some of our friends at BNS and I said, can you explain to me what this really means? So, there's really 3 items that must be met. And those 3 are, you have your building final permit, you have your zoning final, your building final approval, your zoning final approval, and your life safety final approval. So if all 3 of those things are met and all 3 of those areas sign off, then they can have their final CO. In contrast, a temporary CO, or TCO, as defined in section 12.1054B, is a time-limited and conditional authorization. A TCO only allows for partial or temporary use of a structure, meaning the structure is safe to occupy for limited purposes, even though some non-critical work might still be incomplete. So to go back to my 3 items analogy, at least one of those items is not met. So either your building final approval, your zoning final approval, or your final life safety approval is not met, or maybe all three. Allowing beer permits based on a temporary certificate of occupancy may complicate our city's code enforcement and zoning compliance processes. It could allow beer permits to be issued before all building, zoning, and fire safety requirements are fully satisfied. We've looked also at how other local governments in Tennessee who have beer boards handle this, and our research shows a consistent practice across the state and across cities. They all require documentation indicating full code compliance before issuing a beer permit. We didn't find anything that expressly authorizes permits issued upon a temporary certificate of occupancy. So, given the plain language of the code and the relevant legal authority and the practices of other Tennessee cities, our office recommends that the beer board and the board of mayor and aldermen maintain the existing requirement to have a final certificate of occupancy before a beer permit is issued. If the board wishes to explore creating a path for beer permits to be issued with the TCO, preferably under very narrowly defined circumstances, it would require a formal amendment to the code, and we can discuss that about what that may look like. You may want to look at scope and limiting the authority of that beer permit, time limits, and conditions for converting it into a final CO. So with those thoughts in mind, I'd like now to open the floor for any questions. So the first question that I do have is, does the board agree with the city's interpretation that the plain language of the municipal code indicates that a certificate of occupancy is required, a permanent certificate of occupancy is required prior to the beer permit issuance?
Thank you, Blake. So we'll go ahead at this time, as Blake has requested, to have open discussion and question regarding the topic. I'll go left to right. Alderman Barnhill.
Well, we do the beer permits now based upon you having the CO. So I see no reason to change it. You've got through saying that every municipality or almost everyone that you check with does it the same way. There is no temporary CO provision in issuing a beer permit. And I think that when we start trying to, to water down what we're doing, then I think we're probably just getting that much more of an issue, that much more of a problem when it becomes before the beer permit to us. My biggest concern about the beer permits is the special events. Whenever we have half of Franklin blocked off or a fourth of Franklin blocked off, and we're walking around with beer in our hands, and if that's the case, rather than the CO, I don't see the CO in what we're doing now being an issue, and the way we're doing it.
Thank you, Alderman Barnhill. Alderman Caesar.
Thank you. Blake, can you give us a little bit of background on where this request came from?
Sure. So this request came up recently as we were discussing some other items that that came across our desk, Jessica and I's, that with certain businesses that have potentially not gotten through the zoning process, but all other life safety and for all intents and purposes, everything else was ready to go in a business. But so let me give you this example. The Historic Zoning Commission could potentially deny a request for a business. And if that business has a denial from the Historic Zoning Commission, that could prevent them from getting that zoning final approval from the city. And so in doing so, that in turn prevents them from getting a final certificate of occupancy. And that is how this came up, that by not getting that zoning final approval because of a historic zoning matter, which doesn't have to do with life safety or building safety, it is purely zoning. The business was ready to go, and the thing that was holding them up was the final certificate of occupancy.
Appreciate the additional color. So, having been on the Board of Zoning Appeals, not on the Historic Zoning Board, this certificate of occupancy acts a little bit as an enforcement tool to ensure, because once we provide them the ability to sell beer, then, you know, I don't mind if I've got a fence that's not compliant, or maybe my parking lot spaces are not the proper width. We're open and we're rolling forward. I understand the safety, like the two of the three make absolute sense why I would never be supportive of this. If there's a health or a safety issue or something along that lines, then absolutely we don't want anybody serving beer. We certainly shouldn't even consider having a number of people in a property at that time. The other side of this is, I believe it potentially improportionately weights a component of our community government and gives them the authority to either decide or not decide whether or not a beer permit can be issued. And that, to me, presents a potential problem for us to decide here today. And in doing so, if we were to decide to kind of hold that power through a temporary certificate of occupancy, I think it could allow us potentially to represent people in a way that may not feel like they're being represented well through another board. So I think that's an interesting discussion. And I suppose what you're looking for at the end of this, Blake and city staff, is a recommendation or non-recommendation to the Board of Mayor and Aldermen, or where will this go next if we decide to leave it as is?
That's correct. What I'm looking for today is a recommendation from the beer board as to whether you want to move forward with a proposed amendment to the code to include temporary certificates of occupancy, to allow applicants to have temporary certificate of occupancy for a beer permit, and we would bring that to the Board of Mayor and Aldermen for discussion.
And I saw in your summary a 30-day period is typical and standard for a certificate of occupancy that would be temporary. What happens at day 31?
The director or his designee can extend that time frame at their discretion.
But if we're currently allowing them to sell beer in that facility on day 31, if it's not been extended, beer sales stop.
Theoretically,
Yeah.
So, Blake, as follow-up, you gave that one example. Can you give us an approximate number of, we'll say, exceptions that have come before the city, specifically maybe come before this board in the past year to 5 years?
So let me just give you some color from the last few years of certificates of occupancy and temporary certificates of occupancy. So from our friends at the B&S department, they have issued in 2023 219 permanent certificates of occupancy, 70 temporary certificates of occupancy. 11 of those remained in the temporary certificate of occupancy stage, and 59 progressed to full permanent certificates of occupancy being released. 2024, 224 permanent certificates of occupancy were issued, 105 temporary certificates of occupancy. 15 of those remain temporary, and 90 progressed to a full permanent certificate of occupancy. And then in 2025, so as of this year, halfway through, we have 97 full permanent certificates of occupancy issued, 57 permanent certificates, 57 temporary certificates issued, 25 remain in temporary status, and 32 have already progressed to full certificates being permanent certificates of occupancy. I'm only aware of the one situation where the temporary has been issued.
Alderman Barnhill?
So that's the let me make sure that I understand. That's the only time the historic overlay zoning, that's the only branch of the government here in Franklin that could hold up that beer permit. In other words, if they deny, and I'm curious, how does the historic overlay zoning, what When does it come into effect?
So I actually asked for the numbers on the historic preservation overlay, and I think the historic zoning piece of this, historic zoning is a small piece of of this whole puzzle. So
Okay.
in 2023, 21 full certificates of occupancy were issued for the historic preservation overlay, with 12 temporary issued for the historic preservation overlay. In 2024, it was 27 permanent certificates of occupancy in the HPO and 13 temporary issued in the HPO. And this year, you only have 5 certificates of occupancy that are permanent issued in the HPO and 4 temporary issued in the HPO. And 2 of the 4 have yet to be fully released. That kind of colors it in a little bit for you.
Yes.
So Blake, follow-up question on that regarding these that go into this temporary CO status and transition into receiving their full CO. Do you have a time frame and an average time frame that that's taking?
I don't have that on hand as far as once it's issued. Typically, it's 30 days. Oh, hey, Tom.
We'll invite you to the podium, please.
Good evening, I'm Tom Marsh, Director of the Building and Neighborhood Services Department. I'm sorry, what was the question, like time frame for temp COs?
Right, I was just wondering if we're talking few days, weeks, months.
Usually that minimum of 30 days, and it's really too hard to say. Because in terms of adding additional color for like things that might hold up a full certificate of occupancy in the transition, the example of what happened recently with a property in the historic zoning overlay, historic preservation overlay, and actually that was related to a painting issue that, because in renovating their property, the proprietor violated and did not comply with the certificate of appropriateness issued by the Historic Zoning Commission. So that's the piece that held up the full zoning approval, is that they did not comply with their certificate of appropriateness, and that was based on a painting of the exterior. In other areas of the city, and I didn't study all of the temp COs that have been issued, but I can just safely say generally one of the significant issues that often is the transition between a temporary certificate of occupancy and a final certificate of occupancy. And a lot of cases now, especially when you're talking about greenfield development, a lot of things are related to stormwater management. Stormwater management features are not finalized, and they're not fully compliant with whatever the stormwater management plan was. And that it might take them 3 weeks, it might take them 3 months to act. So it's hard to say without looking at specific cases what that transition time is. I don't want to point out one particular issue, but that's one that seems to come up a lot, is stormwater management features in the field are not completed, and everything, building is safe, fire, life safety is fine, everything else related to zoning is fine, but we now do not release the full final certificate of occupancy until stormwater, water management, streets. In some cases, you could also have off-site improvements and turning lanes and things like that related, for whatever reason, related to an off-site improvement that's not finished. And through the entire approval process, from we're talking greenfield development that started with a site plan approval a year and a half ago, that staff put a requirement, okay, we can let you start building, but we will not issue a final certificate of occupancy until these traffic improvements or traffic management improvements are completed. Right turn lane here, right turn lane, something like that, that's an off-site that could also hold up a final CO. There again, is it 30 days or 3 months? So it varies.
Thank you, sir. Any additional comment?
I wouldn't mind.
Mr. Chair, I didn't fill out the card, but I have a lot of input.
Normally, we don't have additional comment from the gallery, if you will. Blake, is there anything else that you needed to present on this?
No, Mr. Chair, I was just going to ask for, after you all have further discussion, if there is an action taken as far as whether you would like a recommendation or not, or deny a recommendation.
Tom?
I guess before you move on, there was one of the other points of discussion earlier that I thought would chime in on in terms of what happens on day 31. If a temporary certificate of occupancy has been issued, whatever the expiration date is, sometimes we know when it's issued. Oh, that's going to take them more than 30 days. Go ahead and put it for 90 days out or whatever it is. And actually, day 31, what that means, the way the process really works, is they are just operating and occupying a building without a certificate of occupancy. And at that point, really, we're in our standard enforcement process where we would issue them a notice if we don't have a reason to extend the certificate of occupancy. And often we're aware of the situation and it's not a problem. Technically, they formally request to the building official to extend their temporary certificate of occupancy, and usually that's done. Normal enforcement process would be we issue a notice of violation. You are operating without a certificate of occupancy. You have 10 days to get legal. Just like all of our other code enforcement processes, usually, we have that time to comply based on a judgment call of how long it will take them. Usually to renew their temp CO, it would be, do it tomorrow. But, give them 10 days to get something done. Then if they haven't complied, then it's the citation to municipal court, where that could be next month. And then each day, remember the way that's set up, each day that they're operating or committing that violation is a separate violation. So if they are operating without a valid certificate of occupancy, each day that they're open without that CO is a violation. And then we go to municipal court, and if the judge finds them guilty of operating without a CO or being open without a CO, she can fine them up to $50 per day each day that they're open. So it's kind of what happens on day 31.
Thank you.
Any additional comment, Alderman Caesar?
Yeah, I suppose I'm a little bit split on this one because I don't want to disproportionately empower something maybe as insignificant or significant as a determination of a paint color, right? I also think that we, as a beer board, have some discretion with the TCO. So there maybe, in my mind, maybe there's a hybrid approach. So it's not either you have a temporary certificate or you don't. Maybe there is a middle ground where we have the opportunity to either allow the beer the beer permit to be issued based on particular guidance that we provide, whether it's upon certificate of occupancy or upon temporary certificate of occupancy, essentially holding the decision on whether or not we issue the permit in the beer board. I don't know legally if that is a just option. And I'd love to hear your thoughts on that, or maybe you need some more time to think and research if that decision-making authority could rest with the beer board on whether or not we choose to issue a beer permit based on the TCO or CO, just as we do hearing and speaking with the applicant.
Sure. So in that situation, what you're specifically speaking to would require an amendment to the code, because right now, as it reads, it's a permanent CO is required. So what we would need to do is this body would recommend an amendment to the board, mayor and alderman, and we would go and have this same discussion with the board.
So Alderman Barnhill, and then I'll have a comment. Go ahead, sir.
Well, under that beer permit, that applicant would not get to us. Shouldn't it be stopped at the staff level? I mean, if there's a violation of the code and they're asking for a beer permit, the beer permit shouldn't even get to our level here. It should stop, will it? So, you understand what I'm saying?
That we should
They're
only hear certain COs.
Yeah. It would be a qualified application, and they would not be qualified because they are not meeting the standard at the time.
I'll say for Jessica, because she's not at the microphone, she says that a lot of times they don't know at that stage. And
The staff doesn't know.
What were the applicant?
Well, the applicant is,
Well, so I
The
think,
applicant
I
would
think what
find
you're
out when he-
saying is if the reason the applicant doesn't have the CO is because there's some sort of violation, that it shouldn't come before you. But a lot of times applicants have just started the certificate of occupancy process. They've just submitted their application. and at the same time, they're also applying for their beer permit. So when we come before you, that process is just getting started, and maybe there's not a violation because it hasn't gotten before an inspector. So I'm telling you that the only thing we don't have is the certificate of occupancy, and asking for contingent approval. There's a lot yet to be determined on the certificate of occupancy in some cases when we're here at the beer board.
Then maybe we shouldn't issue a beer permit without the permanent CO. I mean, you were asking us if we want to, if you issue the beer permit based upon the temporary CO, maybe you don't need to be issuing the beer permit on the temporary CO.
Right, and we're not currently.
Currently, right.
Right.
Right, and that was our recommendation, that,
Okay, right. Yeah.
So the current process, if, just summarizing what Alderman Barnhill just stated, the current process allows us to pass that contingent upon them receiving their CO, which means that we are not stopping them from moving their business forward as soon as they meet all of our city standards.
that's correct.
And we are helping them to move that forward in our current process.
That's correct.
Yeah, at this time, and we've heard from Alderman Barnhill and Alderman Caesar, I'll weigh in as well. Based on what I'm hearing, I recognize there may have been one exception right now, but for one exception to change the process, recognizing that the board is willing to work and provide the beer permit contingent upon the receipt of the CO, I say that the current process actually is working right now. If we need to come back and review this, if there's additional data, then I would be in support of reviewing that data, but at this time, it appears that the process is working. Any other
agree.
comment?
I agree.
Alderman
I don't disagree.
Barnhill?
I have some reservation, but I don't disagree with the statement. I just, I worry about a business who's done 99.5 things right, and there's one little piece that doesn't affect safety, health, function of the business. It could potentially be an aesthetic thing, and we're essentially putting them in a severe financial displacement because of one of the elements. Now, that element's important in times, but if it's not always one of the most important things. And I don't think this should become commonplace, but I am reluctant to relinquish that authority because at times exceptions are important. Even though there's only been one, I think they are important. I think our process currently is working. However, there has been an exception already that's been granted. So how did that fall under the process, or did it fall outside of the process? So if we choose to do nothing, currently a temporary approval was allowed to receive a beer permit, yes?
Yes.
So if we choose to do nothing, that exception still is available, or it's no longer available because we're discussing it here today?
I think that's part of the reason we're having this conversation, to clarify that was your intent when you are issuing those permits based on certificates of occupancy, because we're not specifically saying that in our motion. And just clarifying that that's what you are intending, is that permanent certificate of occupancy.
In my experience, and Clyde, I defer to you, but the 3 years that I've been on the board, I think that has always been the intent.
I think that, yes, I think it's correct.
Okay. So, recognizing that, it appears that the board is willing to move forward as the process and keep that in place. So there is no need to make a recommendation to the Board of Mayor and Aldermen at this time. Is that correct?
That's what it sounds like to me.
Okay, so it's good discussion. If something else surfaces, would you please keep us informed? And we certainly welcome the public input on this as well. But thank you very much, Blake.
All right, thank you.
Yes. Next, we'll move forward to the next item on the agenda, which is other business. Is there any additional business to be brought before this board at this time? Seeing none, we'll move forward to our favorite motion.
Motion to adjourn.
Second.
Motion has been made and properly second. All those in favor?
Aye.
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 Any opposed? Ayes have it. We are adjourned.